the hour here. So we're going to go ahead and get started. We are talking about regulatory enforcement. This is a two-part series with Elizabeth Lees. And quick housekeeping before we get going. This is not legal advice. It is only for training and informational purposes only. About 1 hour. There are a lot of slides, so Elizabeth will probably be going a little fast today to get through all the slides, but some very important information. Certificates of attendance will be auto-generated to live attendees only of today's broadcast. Post your questions at the end as well. There is a question box in your menu. Also, upcoming topics and recordings of past broadcasts are now on our website at silocompliance.com under the AML Gray Matters tab, and you can see upcoming topics and previous recordings as well. I'm going to turn off my camera. And Elizabeth, I am going to let you take it from here. I will be navigating the slides, so if I'm moving too slow, just tell me next slide, please.
Thanks so much, Kimberly, and thank you for having me back again to speak on AML Grey Matters. I know it's so popular and everyone is really grateful for the service you provide in these sessions to help compliance and regulatory professionals. So thanks for having me. And this time we're doing two parts. So this first part is going to be what are the powers, what are the penalties in relation to regulatory work. And then the second part that we're going to do is what to do about it if you do receive one of these enforcement notices. So for today's session, as you said, there's quite a lot of information. So I will do my best to make sure we keep on time and get through everything that we have listed here. So in terms of the powers and enforcement actions, we've divided them into three parts. So first, the administrative fines. Second, other administrative enforcement action available to the regulator. And third, the criminal prosecution option. Then we'll take a brief look at regulating the regulator. What do the international standards say about the regulator and how it should or best use these enforcement powers? And then we'll finish by looking at some of the consequences of such enforcement action. And I think just before we start, Kimberly, there's a poll about whether any of our listeners have a current entity or a previous entity which has been subject to regulatory enforcement action.
Great. Tom, can you issue that poll for us, please?
Sure, I'm just looking here. The next one is, has your current organisation or previous organisation been subject to any regulatory enforcement action?
Yes, that's correct. And Elizabeth, while they're answering that poll, are you seeing a rise in Cayman with enforcement actions being taken?
Well, we'll have a look, Kimberly. I know the one that most people are concerned about are the fines. We'll have a look at the fines that have been imposed and when. We haven't seen one for a while. That doesn't mean one isn't about to come. We don't know. Most of these fines are nearly always, if not always, published. So we are able to see all the fines that have been issued that we'll be looking into. So we'll also look at the obligations under the international standards and globally as well, that increase in enforcement action that's been taken.
Okay, so our poll results currently are showing just under 20% are saying yes. And again, I didn't take a look at our registrants list, so I'm not sure if everybody here is from Cayman or the majority is from Cayman or not. But yeah, so just under 20% are saying yes, they have their current organization or previous organization has been subject to an enforcement action. That doesn't necessarily mean a fine, though. That could be some administrative action, correct?
Yes.
Yeah.
Yes, any regulatory action at all. And we'll see
Yeah.
also that for the fifth round, all regulatory action is, of course, relevant and goes to whether or not we're showing improved and increased compliance.
Okay. Yeah, and 66% are saying no, 11% don't know or prefer not to answer, and 5% are not applicable. Thank you, Tom, for that. And thank you to the audience for responding to that. Okay.
Yes, I think 20% is an interesting figure because it shows that you know, about a fifth of the people listening have at some stage or another been subject to regulatory action. And when we talk about this increase in enforcement action, I don't think that would have been the case perhaps 2 or more years ago. So when we move on to the fines now, the first item that I wanted to make everyone aware of is the Monetary Authority Act contains the power of CIMA to impose these administrative fines. And that fining power extends not only to a body corporate, but the Act was amended to make very clear that this also includes partnerships, limited liability partnerships, and exempted limited partnerships. And these breaches relate to the Monetary Authority Act, any of the regulatory laws, and the anti-money laundering regulations, which is what we'll be looking at today. Now, the other part of the Monetary Authority Act amendment that I wanted to bring everyone's attention to is that it was made very clear that where a director, manager, secretary, or other similar officer or a person purporting to act in such capacity, where the body corporate commits the breach, and that breach was committed with the consent or connivance, or is attributable to the neglect of that particular person in charge, then both the person and the body itself commit the breach. And so this amendment was really important to show that both we saw it can be any type of entity, and secondly, that these individuals in these positions can also be subject to these fines. So in terms of the fines and what they may involve, we can see on the next slide these two categories. We have the serious breach and the very serious breach. So for the serious breach, the maximum fine is $100,000, and for the very serious breach, it is up to $1 million, and that's per breach. So we'll come on in a minute to show how these compare to each other, but just to give you here a sense of how high these fines can go. And you can see here I've provided an example under Regulation 5D, and this is what we were talking about at the beginning, Kimberly, before we started when you did your poll. There's an obligation under the AMLRs to provide training, and a breach of this regulation is categorized as serious. So that's our 100,000 maximum fine. And then I've provided an example of a very serious fine, which would be under Regulation 5B. And this is where you form a business relationship or carry out a one-off transaction without complying with your identification, your CDD, your record keeping requirements. And that is categorized as a very serious breach. So that, by a body corporate, would be subject to a $1 million fine. So you can see here that I've compared the powers of CIMA and the other regulators. So there was a change in Cayman. I think last time we spoke, CARA was still the regulator for lawyers. That's now been changed to the LSSA. We have DCI for real estate and dealers in precious metals and stones, and SEPA for the accountants. So you'll see here that for individuals, there is a difference between the powers of CIMA and the powers of those other regulators. In terms of the body corporate offences, you can see here that CIMA can go up to $1 million and the other regulators can go up to $250,000. Now, you'll see on the right here, the limitation period for these serious and very serious offences is 2 years. That means 2 years from when it came to the attention of the regulator. And also, you'll see that I haven't referred to minor fines here, not because there aren't any, but there aren't any in relation to the breaches of the AMLRs that we're talking about today. And I mentioned the individual penalties. You can see that they're slightly lower. Serious $50,000 and very serious $100,000. And it's important to reiterate again that this is per breach, not the total amount.
Okay, and that when you talk about the one slide you had, they did not give training. So would a breach be like per employee?
No, that would be if
Okay.
it was for the entity, it would be the fact that they didn't give the training that they were required to give. But of course, it could be ongoing if it was no training over a prolonged period of time.
Okay, interesting. All right, thank you.
So if we look then at the fines that CIMA has imposed, and this is what you were asking about earlier, Kimberly. So we see on the CIMA website that there have been 11 administrative fines imposed. 7 of those relate to breaches of the AMLRs. And in relation to those 7, there's 33 breach types referred to, and I've listed those here. So you can see, for example, there were breaches in relation to CDD obligations, breaches in relation to risk assessments, a breach in relation to failing to adequately perform ongoing monitoring. And I mentioned earlier when you asked Kimberly that the last fine on the website at the moment was December 2022. And the biggest fine that we've seen so far is over $4 million, which goes back to that point about it is per breach. And those fines have been issued to a range of different license types, including investment, securities, insurance, trusts. So it's not limited to a particular license type. And we can see from both the anti-money laundering regulations as well as in the case of CIMA, they have their own monetary authority threshold regulations. They're called the Monetary Authority Admin Fine Regulations. So under these two pieces, all the regulators have these 3 principles. Disgorgement, that is, you mustn't profit from your breach. So if this has made you money, then you must not keep that money. Disciplinary, of course, there must be a punishment and deterrence to deter others from committing a similar breach. So there are 3 overriding principles, and then we see criteria that are taken into account, such as the nature and seriousness of the breach, whether the breach was intentional, how long it lasted for, whether any measures were put in place to prevent it, whether there was any intent to conceal the breach, whether the breach caused any financial or other damage, whether the entity or indeed person has been subject to any similar fine, or their overall history of compliance. So we looked, Kimberly, at some of the fine notices issued by CIMA, and you were also asking about an increase in enforcement action. And if we look globally, just this month, we saw that the crypto firm Haven was fined over $12 million in Abu Dhabi, and part of that penalty was issued by the Financial Services Regulatory Authority of Abu Dhabi Global Market. And they said Haven failed to establish and maintain adequate systems and controls to manage its operations and risks, as well as to recognise and record all of its client relationships, breaching the FSRA's anti-money laundering requirements. So that was in April this year for Haven. And then we also saw earlier this year the firm called Block, a digital payment company, and this was a coalition of some 48 state regulators who fined Block $80 million in America for violations of the Bank Secrecy Act and the AML laws, and this was published by AML Intelligence. So we see in the news these increases in regulatory enforcement actions and fines. But I think the real question, Kimberly, that we'll come on to and that our next poll is on is whether these fines that are imposed by the regulator assist in achieving a culture of compliance.
Okay. All right, thank you. Very interesting and a bit nerve-wracking. And I also saw that the one CEO was barred from working in financial services as well.
Yes, and when
As,
we come on to that was in the case of Haven,
mhm.
um, and also we see, for example, the requirement to have an advisor or a person who reviews either what you're doing and how your systems are running generally, or your remediation of the particular breach. And we see imposition of those as actions taken by the regulator, either instead of, or in these cases, in addition to fines, which is an additional enforcement tool that we'll come on to.
Okay. Tom, can you launch the next poll, please, on culture of compliance? There we go. Do you find that the imposition of fines by the regulator assists in achieving a culture of compliance? Now, that's interesting because that's, to me, hard to measure. How would you measure a culture of compliance?
Well, that's a really interesting question, Kimberly, and it's something we'll come on to when we look at FATF and their requirements. So I suppose culture of compliance has two elements, really. One is, generally speaking, in your organization, is there a culture from the top down that encourages the whole organization to comply, and that this is a priority? And that's why regulators look for things like sign off by the directors, involvement of the directors, and that leadership level. And then the second point that FATF looks at is whether or not we're seeing an improvement in overall compliance by entities. And of course, things like, are entities properly assessing their risk? Do they have a sanctions program in place? Are the regulators looking at that and making sure that they do? So I think it's interesting that we can see here that 45% of people are saying yes, imposing these fines assists in achieving this culture of compliance.
Yeah, 45% are saying yes, only 9% are saying no, and 37% are saying depends on the organization. I could talk, I could ask a million questions just about this one alone, but I know we've got a lot to cover, so I will not. Okay, we can end that poll, Tom, and thank you. Okay.
So if we look then at the other enforcement tools available to SEMA can suspend the license or revoke the license. SEMA can require that a person such as a director, an operator, or a senior officer is substituted. They can appoint a person to assume control of the affairs of the licensee, which is one of the actions we just talked about, or appoint a person to advise the licensee on the proper conduct of its affairs. And SEMA can also apply to the Grand Court for an order that the company be wound up, or the trust be wound up, or the partnership be dissolved. And the other power available to SEMA is to mandate an audit. So I think you made this point earlier, Kimberly. It's important to recognise it's not just administrative fines that are enforcement tools available to the regulator, and in the case of the Cayman Islands, to SEMA, but also these other enforcement actions that may be taken. So SEMA has an enforcement manual. It's publicly available on the website, and SEMA says that the effective and proportionate use of its powers to enforce the requirements of the regulatory laws and other relevant legislation plays an important role in pursuit of its regulatory objectives, and SEMA endeavours to exercise its enforcement powers in a manner that is transparent, proportionate, and consistent with relevant laws, policies, and procedures. And SEMA will also seek to ensure fair treatment of those who are subject to the exercise of its enforcement powers. So I know you talked about that was slightly scary, but hopefully this is reassuring in terms of the due process that will be applied. And of course, we'll be talking next time about the different responses that may be available.
Okay.
SEMA,
And I noticed on the last slide, sorry, that they said, they can appoint a person to assume control or to advise a licensee. Who are these people? Are these people from within SEMA, or are these maybe like accounting firms or audit firms? And I'm assuming the company itself would have to pay their salaries or their fees. Is that correct?
Yes, in both cases, it's made clear that the regulated entity assumes the fees, and that in fact is one of the considerations that must be taken into account. Can they at this stage now afford to pay those fees? And that's both for the controller as well as the advisor. The advisor might be used before the controller is appointed, so both controllers and advisors are options available to SEMA.
Okay, interesting. Thank you.
So in the enforcement manual, SEMA also lists considerations that it will take into account, and you can see that some of these are, as you would expect, the nature and extent of the contravention, for example, the willingness and ability of the party to cooperate with and assist with the authority in its investigations and implementing its requirements. And I think they're two important ones. Are you willing and able to assist and remediate? And what is your previous compliance history? Has any previous action been taken against you? Then, of course, the amount of loss that's been incurred due to this breach, whether it's led to any crime being facilitated, because, of course, there need not be a crime facilitated in order for there to be a breach. Whether the entity followed, for example, SEMA's guidance, and also any other action taken in previous or similar cases. So, Kimberly, one of the enforcement toolkit items that we saw was the revocation of the license or the deregistration if you're a registered person. And this is from SEMA's website, where we can see that there have been securities registration cancelled and directors registration cancelled. So these are published on SEMA's website, and these are some of the enforcement actions available to SEMA. And if we just look quickly at the DNFBPs, so this is our other regulators that we mentioned earlier, SEPA, the LSSA, DCI, they may also cancel the registration of their registrants, of their regulated entities. For example, if a person is not fit and proper, or if they have ceased to carry on the relevant activity. The other important point, Kimberly, and one that I think goes with this enforcement toolkit, is whether or not this action will be published. In some cases, publication is mandatory under the law. In other cases, it is discretionary. And SEMA does have a policy on this, and it's called the Publication of Enforcement Actions Taken, the procedure on this. And SEMA say if it's a discretionary matter, they consider the extent to which publication may assist the authority in carrying out its functions. It may protect the reputation of the Cayman Islands. They'll consider the extent to which this publication could cause unfair or undue damage to the subject's business, and also the severity of the breach. So that's from their procedure on the publication of enforcement actions. SEMA also has a procedure in relation to the issuing of administrative fines, and that procedure, Kimberly, which is on the next slide, also talks about publication. And here I've put the extract of the procedure for issuing administrative fines, where SEMA say they consider the enforcement of the regulatory laws, regulations, and AMLRs to be a matter of substantial public importance. And on that basis, full details of the administrative fines imposed, and this includes the name, the provision breached, the amount of fine, and the date of the breach, and a summary of the facts, and any other further relevant information will normally be published. And so we saw on the earlier slide the number of fines that have been published and what they related to, and this is consistent with this policy that these fines will normally be published. But they do say in exceptional circumstances, such as where there's a risk to national security, critical ongoing investigations, or the island's financial stability, the decision whether or not to fully disclose details will be made by the executive committee of the board of directors of the authority. So we see both in the enforcement manual the criteria that's used, and also in relation to fines, this fact that CIMA considers this to be important to publish, but there are these exceptional circumstances.
Okay. And is there a kind of process or appeals process where a company, if they are fined or they're fighting it, is there a process for them to go to CIMA and say, we don't want anything published?
Yes, and I think that's particularly important in relation to those discretionary fines that we spoke about, Kimberly. If there's a discretionary enforcement actions, whether the publication is mandatory or not. So in the case of a revocation where it's mandatory by law, then of course that's more difficult. If it's a discretionary publication for those other enforcement actions, then of course it's open to make representations to CIMA about those. And if there is an appeal or another such action ongoing, which we'll talk about next time, then of course that ties into this question about publication.
Okay, thank you.
So we talked about fines and other enforcement actions, and that ties in with publications both for the fines and the other enforcement actions. And the third item about the powers and the penalties that may be imposed on those involved in regulatory financial business is the actions that can be taken by law enforcement. In the Cayman Islands, failing to file a SAR is a criminal offence under Section 136 of the Proceeds of Crime Act. And what's interesting about this criminal offence is it's not just if you know or suspect, but also if you have reasonable grounds to know or suspect that another person is engaged in criminal conduct. In those circumstances, then you must either make a disclosure to your MLRO, or the MLRO must make a disclosure to the FRA, in the case of the Cayman Islands, the FIU in other jurisdictions, and not doing that is a criminal offence. Under the legislation, under Section 136, there are some defences. Reasonable excuse hasn't yet been defined, but that is an option. Legal privilege. This one is interesting, I think, here, C, Kimberly, and this is where the person doesn't know or suspect themselves, and also they've not been provided by their employer with training specified by, for example, CIMA in its guidance notes. So if you are sort of a trainee, a paralegal, or someone of that nature, and you have not been provided with training by your employer, this could be used in relation to that offence of, did you know? Well, no, you didn't know or suspect. Should you have known? And then you may be able to rely on this section as a defence if you weren't provided with this training. So I think it goes back to that point you were making earlier about how important that training is. And then in deciding whether or not a person committed an offence, the court will consider whether guidance was followed, again bringing us back to the importance of that guidance issued by CIMA. So this is an offence which I know scares a lot of compliance professionals in terms of failing to file a SAR. We haven't seen a prosecution, or there hasn't been a public prosecution that we know of in relation to failing to file a SAR, but we did see recently, in fact last month, in Switzerland, in the case of Credit Suisse, that the former chief compliance officer was fined 100,000 Swiss francs, Kimberly. This is on the next slide for Credit Suisse. And she was fined in relation to failing to report This was published by various news outlets, and it's important to note that they did say that the individual is contesting this fine, and this related to a bigger scandal in relation to Mozambique and the misuse of bonds and corruption. But this individual was fined for her role in relation to failing to report a suspicious transaction some time ago. And this has just been published last month.
Yeah, I saw this one actually when I was reviewing the slides. I thought that's 9 years. It's from, so she should have reported it in 20, was it 16, I believe?
Yes.
Yeah, and I'm sitting here thinking, I wouldn't know what I did 9 years ago. This is one area where I do tell people whenever I'm working with them, make sure you leave very good notes as well, for yourself, because you never know when something's going to blow up, even if you don't suspect anything. And I just thought that this was fascinating, and I'm sure others will also um, have some concerns about this. And I think my question is this typical that this kind of time can pass? Is this kind of an outlier situation? And is there ever going to be any kind of a time limit for fines against an MLRO or others in compliance at an organization when they should have done something? What's your take on this particular situation?
So we'll come on to the penalties in a moment, but in relation to this particular offence in the Cayman Islands, the offence carries a penalty either in the summary court or in the Grand Court. What that means, Kimberly, is it's an offence triable either way. And that means that the limit that would apply to summary only offences, which is 6 months, does not apply. So there is no such limit in relation to these criminal offences in the Cayman Islands. The other point that I would make here is that we see globally, and we see in this particular case, that these failure to report offences are often tied to criminal money laundering, larger schemes or
Okay.
acts separate to the failure to report itself, which is often, in fact, how the failure to report comes about. And as we know, Kimberly, those kinds of investigations can take a very long time. So it may be that that investigation is ongoing before the failure to suspect is located or notified. So it does, I agree, it seems like a long time, but I think those types of money laundering investigations can take a long time. And I suppose it also depends when the actual failure to report comes to the attention of the authorities during the course of that larger investigation, and whether that's
Okay.
dealt with separately or whether it's part of the bigger investigation.
Okay. Thank you.
The other offence that we should talk about here, Kimberly, which is a new consideration in the Cayman Islands, is the actual substantive offences of money laundering, which we find under our Proceeds of Crime Act, sections 133, 134 and 135. So the new change that came into effect in the Cayman Islands in 2025 in January is that, as opposed to simply filing the SAR, if you are now going to take an action which may cause you to be subject to those offences, for example, moving the suspected proceeds of crime, you now need the consent of the FRA, which is our FIU, in order to have a defence to those substantive offences of money laundering. We were expecting to see regulations about this. We haven't seen them yet, but the FRA did issue an industry advisory, and they have said that you must file your SAR and your defence request for a defence, which is now a new section that you can fill in. And they have said that the FRA has 7 working days to respond, and if no response, consent is deemed granted, which suggests that you don't have to wait to here, yes, you may continue, but you must wait for those 7 days. If consent is refused, then during the next 30 days, you cannot proceed with whatever transaction or action you were going to take that you've requested a defence to making. So that's the industry advisory that was issued very shortly after the legislation came into effect, and we understand that regulations will be issued very shortly. And I know you've spoken about this on your webinar as well, Kimberly. So that's the offence of failing to report. Be careful that you've got a defence to the substantive offence of money laundering, and then the other offence is tipping off. And this is where there's circumstances where a SAR should be filed, doesn't matter if it was or not, but there's a suspicion, and somebody makes a disclosure which is likely to prejudice the investigation. That is also a criminal offence, and it's very important that you have policies and procedures in place and that you're aware of that in terms of the course of your activity within the regulated financial business. Kimberly, for those offences, that failure to report, 136 is the broader offence and 137 is specific to the MLRO, and then 139 for your tipping off. For those offences, in the summary court, you will be liable to a maximum fine of $5,000 and imprisonment of 2 years. But in the Grand Court, that is imprisonment of 5 years and an unlimited fine. So these are not insignificant penalties for these offences. The other item that I wanted to bring to everyone's attention is that under the AMLRs, we talked about the breaches, we talked about the power to fine. There is actually also this criminal offence where if you breach the regulations, you commit a criminal offence. And again, in the Grand Court, you could be subject to a fine and imprisonment for 2 years. So how then is it decided if it is to be an administrative fine or a prosecution? So I've summarised that on the next slide, Kimberly, and you'll see that for the regulators that are not CIMA, it says you may impose a fine or you recommend to the DPP that there may be a prosecution. Of course, only the DPP can make that ultimate decision about the prosecution. But in CIMA's case, it says the fine does not preclude a prosecution, although it does say when considering the amount of fine, CIMA will consider any penalty imposed on conviction. And CIMA's enforcement manual goes through the stages and the considerations that it will give to whether or not any particular enforcement action is suitable. And it also deals with this ability to refer to the DPP. So just to bear in mind, Kimberly, a breach of the AMLRs is not only subject to a fine, but also subject to prosecution. So in terms of whether it would be the individual or the entity that is prosecuted, I think we have another poll here, Kimberly, to ask the audience who they think should be held most accountable in case of these AML failures.
Yes, and while that poll, Tom, if you can issue that one, I've got 2 people have posted questions, and one has just popped up, and I recognize the name, so he's from Cayman. He says, if you need the FRA's permission under the Defense Against Money Laundering regulation, how do you avoid not tipping off when the recipient asks where there is a delay in processing their payment and the FRA has not yet provided consent? And we did talk briefly about that in a recording. I will reach out to you with that link, or you could go to our website to look at that recording. It is tough, and I used to work in London, and we had the similar situation. You do need to train your staff very, very well how to handle those situations. Sometimes too, it's also about managing client expectations and just saying, hey, this can take, things can take 7 days. Interestingly enough, I've also noticed that payments coming from Cayman to me personally are, not as fast as they used to be, but I understand why that's the case. Um, so that's the only answer I have for you on that, Gary. Do you have any tips as well? Because I do know that it's a huge concern for our
Yes.
Canaan
Um,
compliance officers that are new to this kind of regime.
Yes, and I know that the director of the FRA here, RJ Berry, has been diligently doing the rounds and speaking at various events, including at the Cayman Islands Compliance Association.
Mhm.
And some of the suggestions relate to the terms and conditions, generally speaking, that may cover this, as well as having some kind of script that is used. And that goes back to your point, Kimberly, about training of the frontline staff.
Mhm.
And also that careful consideration was given to the length of time, which does appear to be in line with the shorter time of other jurisdictions, some of whom have a longer time, which makes this tipping off provision even more difficult to comply with. And the other point that I think is important to note here is that as well as the regulations coming out, we also expect to see guidance, and there will be guidance published to accompany those regulations issued by the FRA. And we expect or hope that this may cover some of these items.
Yeah. Um, Again, I could talk more about that, but that's a whole separate subject. Gary, feel free to reach out. Happy to chat with you on that. Um, so our poll results. Who do you think should be held most accountable in cases of AML failures? 12% say the entity only, 13% say senior management, 11% the MLRO or head of compliance, and a whopping 63% say all equally. Um, and I probably should have given another option of whether it was all equally or all like, based on their role and involvement in that particular case. So thank you for responding to that. We can close that poll now. Was that what you would have expected, Elizabeth?
I think it's really encouraging, actually, 63% saying all equally. So I think there's an
Mhm.
acceptance, and I think a lot of work has been done, a lot of outreach has been done about the role of the individual, the importance of the roles of the directors, of the compliance officer, the MLRO, and how important it is to take these roles responsibly, to provide training, to have all your policies and procedures, and also to make people aware, as we're doing today, of
Mhm.
the consequences and the penalties that may be imposed if that's not the case.
Right. And just to kind of point out too, we keep these recordings on our website. So they are available and they are free. So if you are struggling to train your staff, reach out to us, go to our website, and like I say you could use these recordings to make sure your staff are trained. Um, I mean, it's kind of like our knowledge library, and I do tell people, please utilize it.
Absolutely. And as I said at the beginning, Kimberly, I think everyone's very grateful for the service you offer. And now, with the fact that they're available on your website and can be watched afterwards, it's even
Mhm.
more accessible. I know previously you used to email them anyway if you registered, but now at any time you can go and watch them. So I think that's a really great service that you're offering that hopefully lots of people are taking advantage of.
Yeah, they are. They are,
Okay, so I'm
which
going
is
to
great.
whiz through this bit because it's a bit technical, and then we'll get on to regulating the regulator. Just to make the point here that the Proceeds of Crime Act itself provides for the criminal liability of both the corporate body as well as the director, manager, or secretary where the offence is committed with the consent or connivance or is attributable to the neglect on behalf of that individual. Both the company and that individual are liable to prosecution. So that's a general provision in the Proceeds of Crime Act. And then on the next slide, we see it for the AMLRs themselves. And again, it states where the offence is committed with the consent or connivance or due to the neglect of those individuals, both the individual and the entity commit the offence. And then it goes on to stipulate the penalties that are available. And it says that the penalty is the same as it would be whether it's the entity or the individual. And then, Kimberly, I also wanted to make everyone aware that when those amendments were made to the Monetary Authority Act in 2023, again, it was made clear that when the offence is committed by the body with consent, connivance or neglect of this individual, both the individual and the body can be held liable. And those amendments were also made to the regulatory laws as well. So we see that we're closing the gap in terms of it's not just a body corporate, it's any type of entity, and making it very clear that it also extends to the individuals. So you can see on the next slide, Kimberly, the other acts that were all amended to also make that clear. And then just to add to that, we have those statutory provisions. We also have the provision via common law, because FATF, we'll come on to see, is expecting that where you have high risk legal persons, those legal persons are prosecuted. So how do you prosecute a legal person? Well, you have to look for the directing mind and will. So it's something that lots of prosecutors in lots of jurisdictions find difficult. It's a difficult concept. We could have a whole seminar just on this topic, Kimberly, but I just wanted to make it clear that where it says in law a person, that person who is guilty of the offence could be an individual or it could be a legal person. And when we look to prosecute a legal person, and when we need to show what the legal person was thinking to prove the crime, then we need to look at the directing mind and will, and then we'll go back to, for example, the memorandum and articles to see who is the directing mind and will in that particular circumstance. And again, a recent case, TD Bank, I think we're all aware, and you can find this on the DOJ website. This notification relates to October of last year. TD Bank pleaded guilty. These were violations of the Bank Secrecy Act, and also in relation to money laundering. Employees in this case were involved. It was a big scandal, many fines and penalties, and one of those related to failing to maintain an adequate AML program. So here you can see criminal action taken against the bank in relation to that failure, as well as, it must be said, other failures. And this is one of the examples I spoke about, where the retention of an independent compliance monitor for a period of 3 years was also imposed. And you'll probably remember in this case, we heard officials, government officials, saying this is a case study of what not to do. And if the business case for compliance wasn't clear before, it is now. And the serious breaches that were committed in this offence, in this case, including failing to monitor transactions, which allowed what was said to be hundreds of millions of dollars to flow through to money laundering networks. So that was the case of TD Bank. Then we also had recently this case of Robobank. This is an extract from AML intelligence. This relates to the offence of failure to prevent money laundering, which is an interesting offence. We don't have it here in the Cayman Islands. I think it is an offence in Guernsey and in Jersey and obviously in Holland. And it's an offence which is useful for prosecutors in relation to that issue we talked about with prosecuting the company. So we're not proving the directing mind and will, we're proving this failure to prevent money laundering. And here, the prosecutors have said violating this law can have major social and economic consequences. Money laundering and financing of terrorism is a threat to the integrity of the financial system. And you can see here that it appears that there were some settlement discussions, but no agreement was reached. And it was noted here by AML intelligence that previous investigations for violating money laws had also been carried out by this prosecution authority, also ending in massive fines. So it's something to be aware of. Criminal action can be taken in suitable cases. So just to finish off, Kimberly, if we talk about regulating the regulator and FATF and the upcoming 5th round inspections, in 2022, FATF reviewed what had gone on up to that point in terms of mutual evaluations and compliance with the international standards, and found that countries are not very effective when looking at sanctions applied by supervisors to supervised entities. Performance is low, and that report is available on the FATF website. And we also know that when Cayman was placed on the grey list in February 2021, one of the actions that remained on the grey list that was remediated extremely quickly was applying sanctions that are effective, proportionate, and dissuasive. And that action was remediated very swiftly thereafter and found to be addressed. So, Kimberly, for the 5th round that's fast approaching, there is an updated methodology. A little extract: we've now separated the DNFBPs and the financial institutions, but both contain this provision where they will be assessed on the core issue of the extent to which monitoring and supervision, including outreach, training, and applying remedial actions and/or effective, proportionate, and dissuasive sanctions, has a demonstrable positive effect on compliance. So this is something that will be assessed in the 5th round. According to the FATF website, there are some to be confirmed dates on there where we can see some upcoming dates in the region, and we understand that for the Cayman Islands, the provisional date is a December 2027 on site. So that period is now under review to be examined potentially in December 2027 by the assessors on site. So just to conclude, Kimberly, because I know we're rapidly running out of time, we talked about how the entity and those in senior management may be subject to administrative penalties. We talked about the MLRO and the offence of failing to report. And we talked about the supervisory power of revoking a licence or registration and some of the other enforcement actions available to CIMA. And we also discussed how supervisors must take enforcement action which is proportionate and dissuasive to meet international standards, and this will be assessed in the 5th round with that separation of the financial institutions and the DNFBPs. So there are various enforcement action options available. Obviously, they have severe reputational consequences. The financial consequences can be severe, as we've seen, and also it affects your obligation to disclose in future applications, such as your PQ to CIMA, and how they may be treated. So they do contain these severe consequences, Kimberly, and next time we're going to look at some of the actions that may be taken if you find yourself subject to such enforcement action.
Okay, thank you. So, yeah, we have about 6 minutes left. You did a fantastic job, Elizabeth. I could tell you kind of maybe even ran out of breath a little bit as you try to finish up and get these key points there.
We will finish on time, Kimberly.
We will finish on time. Now, I just know how valuable everybody's time is, and so we wanted to make sure that we do finish up. What would be your number one piece of advice if you, to any head of compliance or compliance officer at a firm, and I'm going to say a smaller firm, not a big firm who has lots of resources, but a smaller firm, what would you say this is what you must do first to ensure you don't get an enforcement action?
I think there needs to be a mapping exercise against the regulations and the guidance notes as applicable to your line of business, and then to make sure that each of those is completed or actioned. You could either do that yourself, you could employ someone else to do it, if you haven't done an audit, you could do an AML audit, which would help you to identify those areas, and then go through and make sure that all of them have been dealt with, or you have an answer to them as to how they will be dealt with. And I think that's particularly important when we see, for example, AMLCOs take over from other AMLCOs. Are you now, as the new AMLCO, confident that everything's in place, or your systems or your policies and procedures, to ensure that you've met your obligations?
Okay. There was one other question. It's not related to Cayman. Let me just see if it's a question. It's more of a statement. They're saying, obviously from Malta, they're saying in Malta, fines are regularly deemed unconstitutional and dismissed, which renders them somewhat useless, except of course for negative publicity. Question: would that not hurt Malta though, if in their next round of mutual evaluation? And thank you to the person who sent that over. So I'm just trying to keep confidential names. Do you think that will hurt Malta if that is the case?
I think it would depend on the proportion of fines issued and the proportion that have been overturned. If, for example, every fine that's issued is overturned, it's hard to see how that would be effective. How would it be effective in promoting remediation if entities simply know they will be overturned? And also, I think we talked about earlier in terms of the procedure, and when you use the word people are scared, the rule of law and ensuring that there's a fair and transparent procedure. If, however, it's a small portion of the fines that are deemed to be unconstitutional, then maybe there are valid reasons for that, and there's a number of other fines that haven't fallen into that category, and then the argument could be made, well, this is a system working effectively and in line with the rule of law where these can be challenged and properly litigated, which is something we're going to talk about next time.
Okay. And yeah, we only have about 3 more minutes. No other questions. A lot of people have commented, thank you so much. One said, wow, well done. You sailed through all that information. So I do appreciate you sharing all of your knowledge and experience with us on this. And of course, you've had that experience as well in the past of helping Cayman get off the gray list, correct? With
Yes.
remediation? Yes.
Yes,
So
and the numerous documents and statistics and case studies that need to be provided. It's a huge amount of work for the jurisdiction, for the supervisors, for law enforcement. And also we've talked about the role of industry and how industry also plays an important role, both in showing they're compliant, but also attending outreach, going to training, all of which helps the jurisdiction to demonstrate that this is a matter that's taken extremely seriously. And we know how important Cayman's role is, and we all play our role in helping it to succeed as an international financial center.
right. Now, and one more question from me, and this, if I was a director of a company, and many of these, especially like professional directors, they're directors of a bunch of companies, and they may only, be meeting once a quarter, or, maybe even twice a year or something like that. What would you say to a director of a company who's there in the Caymans under AML regs? What would you advise them? First thing they should be looking into to ensure no enforcement action from SEMA, one of the other regulators.
Well, first of all, risk and context is crucial, and that's emphasized even more in the 5th round. So in terms of even your meetings and how frequently you're meeting, is that consistent with your risk and context?
Mm-hmm.
Secondly, are you satisfied that you have fulfilled your role in terms of, in the same way as we talked about with the compliance officer, with the director, are you aware of all the policies and procedures? Have you signed off on them? Are you aware of the risk? Have you signed off on the risk assessment, on the risk appetite? Are you satisfied there's a procedure for items to be brought to you? For example, if it's not time for your regularly scheduled meeting, what access does the compliance officer have to you to bring other information to your attention as it becomes relevant, not to wait for those meetings in urgent cases? And does the compliance officer have direct access to you? And is that happening in practice, because of course it's all very well to say it's in your policy and procedure. Are you satisfied that it is happening? If it's not happening, maybe it's because there has been no need for it to happen, but are you making checks to make sure that all of those measures are in place?
Okay, thank you. And for those who don't know, again, we do have a recording on that particular topic, board reports. But I think that's very good, making sure that the compliance officer has some kind of access to you, not just once a quarter or once a month as well, and knowing those details. That's kind of something that I keep counting on to people. It's like it's all in the details, the footnotes, every word, I of these manuals are important. Um, all right, thank you so much, Elizabeth. That was very, very good. You covered so much, and I'm looking forward to the next session on part two, the entity and the individual. You're bringing in Mark as well. That is on the 7th of May, so 2 weeks from today.
Yes.
Yeah, okay, so I'm looking forward to that. And then another upcoming topic I'll be hosting is AML compliance the right career for me? So many of us might be, um, questioning this. Whether you've been in the industry for a while and you feel like you're burning out, but you don't know what to do next, or if you're at the beginning, what's important, certifications. Um, but yeah, so do please join us. And again, you can get all of that on our website, silocompliance.com, under the AML Gray Matters tab. Elizabeth, I'm getting a lot of people saying thank you very much, just so you know.
Well,
So a
thank
lot of
you for
people
having me. I'm glad
very
people found it useful.
right. And you are hosting in person at the Georgetown Yacht Club in the Cayman Islands, advanced AML training. So perfect opportunity for uh, I guess really anybody. You could even get directors there who are looking for that very engaging training session. I would think. I know you said it's suitable for AML, COs, MLROs, deputy money laundering officers, and just others. But are you open, or do you have separate training just for directors?
It's definitely open to directors, and I think it goes back to that question you were asking about what's the role of directors, and do directors understand their role in supervising effectively and being responsible for what's going on below. um, so they're very welcome to come. We have been asked to do a separate session for directors, and we do also provide in-person tailored training to
Hmm.
directors for their particular firm. But stay tuned, we may do an open session for directors as well. But yes, they're very welcome to come to this one.
Yeah, I think it's one of those investments um, that's very important for people to make, especially if they're not familiar with the compliance, the complexity and nuances of AML compliance. Um, I highly recommend directors, getting at least the one-on-one, because it's very specific to your industry, obviously your location as well, the size of your firm. Um, great. Somebody is asking, is there still availability? I think you did say earlier you do still have a couple of spots available.
Yes,
Is
we do
that
have
correct? Okay.
some
Yeah.
space still available.
Yeah. So I do recommend it. I wish I could be there myself. That'd be really good.
We'd
For
love to
those who
have
are
you, Kimberly.
I would love to listen in and be part of that. Unfortunately, I can't. Um, I am hosting a virtual training session. I call it Zen and the Art of AML Compliance. It's really, we go from the FATF and what it's doing. It's the big circle. So if you are looking for online training and you are not in Cayman, please do join me. And again, that is, you can register for that on the website as well. So 4 minutes after, Elizabeth, again, thank you so, so much. I really appreciate it. And for everybody who registered and for listening in, again, the recording will be available in a couple of days on our website. You can also download the slides now, so you don't have to keep reaching out to us. And I'm looking forward to speaking with you again in 2 weeks on May 7th, Elizabeth. Until then, have a wonderful time.
Thank you. Thank you for having me, and I will see you next time.
Thank you. And I thank the audience as well. Thank you for joining us. Please feel free to share invites or let people know your compliance associations as well, because this is, again, a free resource. Um, and we do not pay our panelists, our guests. They do this out of their love for you as well. And again, it's just our way of showing support to the AML compliance professionals that are out there. We know there's a lot for you to have to understand and learn and stay on top of. So please do join us and share this resource with your peers and colleagues. Thank you. Thank you, Elizabeth. And thank
Thank
you,
you.
Tom. Okay.
Bye.
Bye.